Afternoon session of the Court of Appeals. I'm Judge Golden, and joining me on the panel today is Judge McGee and Judge Armstrong. As you know, each side will have 15 minutes to speak on behalf of their clients and or themselves. And there's the appellant can reserve 5 minutes for rebuttal. You may call the case.
Kirby Parkway Professional Condominium Association, Inc. versus Cindy-Jarvis Limited, LP et al.
Good afternoon, Your Honors. This is Attorney Jerome Payne. I am representing Cindy-Jarvis Limited, LP and Barbara Duncan Cody in this matter this afternoon. I'm going to allow Mr. Cody to proceed with the argument, and we join in that argument, Your Honor.
All right, thank you. Mr. Cody, you'll be representing yourself and you'll be arguing the case on behalf of yourself.
Yes, Your Honor.
And you may proceed.
Yes, sir. I just want to first take a few minutes and make a statement concerning the issue of damages in this case, and for all the other issues, the defendants will rely on their briefs. This is the case that was brought, and major allegations in the case was breach of contract and unjust enrichment. And stating right from the plaintiff's complaint, the complainant said that the defendant's failure to pay is a violation or breach of the master deed, and that the association had conferred upon defendant benefits, which I'm guessing that he said they didn't deserve, and that the defendant's failure to pay the assessments has caused the association damages. This court has said on multiple occasions that the party seeking the damages has the burden of proving those damages. In this case in particular, contrary to what the complaint states, at the trial court, there were nowhere in the record does the plaintiff present any evidence that the association conferred any benefit on the defendant, and nowhere in the record does the plaintiff present any evidence that the defendant's failure to pay caused the plaintiff any damages. If you look at the court's order, it should be noted that the court's order does not find that the association conferred any benefit on the defendants, or that the association was damaged in any way by the defendants by its failure to pay.
Mr. Cody, did you raise this in your brief?
I raised it in the brief, but not as damages. I raised it in the brief basically as calling it.
Or not as an issue. Not as an issue. You didn't raise it as an issue. You didn't raise this as an issue in your brief, did you?
As an issue, I discussed it in the brief as insufficient proof.
All right. Let me. I want to ask you a question, because I understand part of what you're seeking here. Part of what I understand you're seeking is the fact that assessment. There was a regular assessment that was ordered by the board. This is back in 2010. With an increase in that assessment of 20%, to be paid out over 5 years, and then the regular assessment to be paid in a normal installment plan as provided by the master deed and the bylaws. And there's no issue about that, is there?
There is an issue. The issue on that, Your Honor, is that the $385,000 assessment. That's a different assessment. I'm talking. There were two assessments. There was a special assessment, and then there was the regular assessment that was increased by 20%. You and your wife and an LP own this property. Is that correct? Correct.
All right, and you don't deny that there was a board of directors that had authority to make regular assessments on the property.
Right. No problem.
That's right. All right. And so there was this regular assessment that you'd been paying for years. In other words, a regular assessment. And that assessment was increased by 20%, and that was to be paid out over in installments over a period of time. That's part of what is being said you owe here. Part of that hadn't been paid. Correct?
That's what it's been said, yeah.
I understand. That's what you've been a judgment awarded against you for that amount that hadn't been paid. The second assessment, as I understand it, was for this $385,000 that was to be used to replace the roof of the buildings and replace HVAC heating and air conditioning units on those buildings. Is that correct?
That's correct, Your Honor. But however,
wait a minute, I'm not finished yet. And your objection is that assessment, all of the owners were assessed a lump sum assessment that was due maybe a month later. I think in your case it was a little over $18,000, and you were objecting to the fact that should have been paid out in installments, just like the other assessment was being paid out. Is that correct?
No, Your Honor. I was saying that the 20% tacked on to the regular assessment is the $18,000 paid out over 5 years.
Okay, but so, and did you not argue in your brief that this additional $18,000 that you were charged with, that your objection to that was that it was not you had an argument that this should have been paid out in installments?
That my argument was that it was paid out as to 20%. And that's paid out in installments.
And didn't you also argue that if you were being charged this $18,000 assessment, that was inappropriately charged to you because it was not being paid out in installments?
I'm saying that $18,000 was not supposed to be paid at all, because that was double assessments. For the 20% and the $18,000 is the same money. My argument is that the $18,000 was properly, the $385,000 was properly assessed, and our share was $18,000. And $18,000 was split up over the 5 years, and for the 20% over 5 years, and that was the increase on the regular assessment.
But you understand that 20% was paid into the reserve fund.
No,
you understand that?
That's a problem with it. The 20% could be paid in the reserve fund. That's fine, because the budget itself, the regular budget itself calls for reserves to be in the regular assessment. Putting the 20% in the regular budget is proper. There is a reserve. Reserves are charged on a monthly basis, just like with the regular assessment. Yeah.
So you're saying now that this $18,000 that you were charged to be charged in a lump sum, and you argued in your brief, which was a special assessment, you acknowledged it was a special assessment.
No, correct, Your Honor. I did not acknowledge that it was a special assessment. I argued in my brief that it was a common assessment. And since it was the common assessment, it was charged it is the 20% that must be charged on a 12-month period basis.
All right, go ahead. Let
me ask you, Mr. Cody, if the special assessment was not paid as a lump sum, how would the condominium have paid for these major improvements if they were waiting to collect that money over a 5-year period? How would they pay those expenses?
It was 20% on top of the regular assessment. Yeah,
I understand. They increased the amount of the monthly assessment, and they only did that for a period of 5 years, and then maybe you went back to what it was before. But my question is, if they were entering into contract for major improvements, how could they pay for that unless that money was paid on the front end, not on just an increased monthly assessment.
If you look at the record, Your Honor, you will see that it was not paid in one, those improvements were not paid in one lump sum. The record shows that those improvements were paid over that 5-year period. And it said, and the letter said that it would be paid out as the money came in, and that the project would progress as the money came in. And that's exactly what happened.
And that's in the record, is that right?
That's in the record, yeah.
Okay.
Go ahead. Oh, well,
We're out of time, yeah.
you're out of time. All right, sir. All right, Mr.
Yes,
McMahon.
Your Honor. Can you
Go
all
ahead.
hear me?
Yes, go ahead.
Okay. Well, Your Honor, I'll just start by saying there are several deficiencies in the appellant's brief. I raised these deficiencies in our brief. Such deficiencies included lack of citing to the record and factual assertions without citing to the record. The appellee did not respond to these deficiencies in their reply brief. So the court, if it deemed proper, could dismiss the appeal for lack of compliance with the appellate rules of procedure, but I will proceed to discuss the merits of the case. The case is pretty simple, and Your Honor's touched on a lot of the points in your questioning. The court only needs to look at the plain language of the master deed. This court has instructed on multiple cases that the courts interpret words through their ordinary meaning. Fortunately for the association, the master deed is clear. The master deed allows the association to collect regular and special assessments. The appellants agree that the association may collect regular and special assessments. Mr. Cody testified to that at trial and discussed it in his brief. In his brief, he questions the timing of the special assessment payment, and we'll get into that. But I'd first like to talk about the regular monthly assessment. Article 13 of the master deed provides assessments for common charges shall be made for each fiscal year 15 days in advance of the year for which the assessments were made. Such annual assessment shall be due and payable in 12 equal monthly installments on the dates established by the Board of Managers. There is no dispute that the appellants fell behind in the payment of their monthly assessments. If you look at page 10 of my brief, I provided a screenshot of a calculation provided by Mr. Cody in a letter where he admitted that they owed over $19,000 in regular assessments. This letter that he provided with the calculation was admitted as an exhibit at trial and is part of the record. Their failure to pay the regular assessments is a breach of the contract. Now, if you turn to the special assessments, Article 13, Section 9 states, all other assessments, either for emergencies or otherwise, shall be made by the Board of Managers in accordance with the provisions of the Horizontal Property Act and the condominium documents. And if the time of payment is not set forth therein, the same shall be determined by the Board of Managers. Okay. The words other assessments are important here. The word other means assessments other than the regular monthly assessments. The master deed clearly allows the association to make other assessments when necessary. The board of directors did exactly that, to fix the roof, to fix to repave the parking lot, to fix the HVAC unit. In March of 2010, they announced a special assessment in order to do all of those things. These were necessary repairs, and the special assessment was validly assessed. Furthermore, that same provision says, if payment is not set forth therein, the same shall be determined by the Board of Managers. The master deed allows the Board of Managers to set the payment date for other assessments, often referred to as a special assessment. The Board of Managers did that. The letter went out in March. They made the due date in April. That same letter says, in addition to the special assessments, the regular monthly assessments are increased by 20%. The record clearly indicates that the increase was necessary to replenish the reserves in order to avoid future large special assessments such as this one. Despite the obvious meaning of the words in addition to and also, the appellants took the position that the special assessment was somehow funded by the 20% increase. They offer nothing but conjecture and cannot cite to any evidence in the record. However, the letter sent to the members is clear, and it does not offer any sort of financing scheme. It simply says, in addition to the special assessment, a 20% increase in the regular assessment was also passed. It should also be noted that the appellants were the only member of in the entire association that did not pay the special assessment, and have now somehow taken the position that the increase was supposed to fund the special assessment. There's simply no evidence to support that in the record.
Mr. McNair, let me ask you, the improvements, were they paid over a 5-year period, or were they paid immediately upon completion of that work?
The bulk of the improvements were done immediately. If I'm not mistaken, the roofs were done and the pavement was done as soon as the money came in. And the boilers, there's two buildings. I think the boilers were done in phases, but the bulk of the work was done as soon as the money came in.
And that total came to how much?
The total came to about $385,000 was the total. I think it may have been slightly less than that at the end of the day, but that was the total of the assessment.
And was all of that work done within 1 year of the special assessment?
I believe so, Your Honor. Yes.
Okay.
Okay. The trial court noted in its ruling that it cited to Article 8, Section 2, which reads, "The board shall have the power and duty from time to time to revise the budget and assessments for a fiscal year on the basis of actual common expenses incurred or estimates by the Board of Common Expenses to be incurred, and in doing so, the board may specify the date as of which common charges and special common charges based on such revision shall be assessed. In the absence of such specification, the common charges and special common charges based on such revision shall be deemed assessed as of the first day of the month following the board action." The association clearly has the ability to levy an other assessment, or in this case, a special assessment. In the appellant's brief and at trial, the appellant's brief and at trial, they also argue that they're entitled to a set-off for alleged excess profits. According to Mr. Cody's testimony at trial and in his brief, however, you do not have excess profits until you allocate for reserves. Fortunately, the association and the master deed agree with Mr. Cody. Article 13 of the master deed provides that the common expenses shall be charged by the board of managers to the unit owners according to their respective common interest, unless specifically otherwise provided. The common profits of the property after offsetting the common expenses relating to the common elements and making due allowance for the retention of a reserve to cover future common expenses shall be distributed among the unit owners in the same manner. At trial, the association's property manager testified that the board of directors determined it needed $350,000 in its reserve fund. They did not have $350,000 at the time of trial. The appellants are ignoring the due allowance for retention of reserve to cover future common expenses. The board of directors is entitled to save for future common expenses. In fact, doing so is a prudent business decision to hopefully avoid future large special assessments such as this one. The master deed explicitly offers such savings mechanisms. The appellants were not entitled to any set-off, and they are not entitled to any set-off. It's also confusing that the appellants are seeking a set-off for money in which it has not paid.
Was that 20% that the regular assessments were increased? Was that money paid into the reserve fund?
Yes, Your Honor.
Okay, all right.
In the appellant's brief, just briefly, a couple more points. In the appellant's brief, for the first time, it raises the issue of a statute of limitations as a defense. This court has ruled on multiple occasions that affirmative defenses must be raised or must be pled. The appellants did not raise such a defense. They did not plead such a defense. It was not raised at trial. The first reference to the statute of limitations came in the brief before this court. So the fact that they did not raise statute of limitations as a defense, it has been waived pursuant to Tennessee Rules of Procedure 12.08, and multiple cases which were cited in our brief. The appellants also alleged the trial court abused its discretion in finding that they breached the contract, and he stated in his remarks that there were no damages. Your Honor, the court found they did not pay the special assessment, or they had not made certain monthly assessments. That is a breach of the contract. Those are damages that the association is entitled to recover. Trial courts speak through their written orders. According to the trial court, the excess funds from 2010 through 2017 were designated as reserve funds, which is allowed by the master deed. And the trial court noted that Article 13, Section 9 empowers the board to set the time of payment for such special assessments. So the trial court correctly came to the conclusion that the appellant's failure to pay assessments and the special assessment was a breach of the contract. The court's decision was based on logic, facts, and the plain language of the master deed. The court did not abuse its discretion. The trial court made the correct decision. The appellants did not pay. Unfortunately, rather than pay, they tried to confuse the issue and somehow place blame on other parties for their failures. This court should affirm the trial court's ruling, as the association acted properly at all times, complied with the contract, the master deed, and complied with the plain language. And unless there's any further questions, Your Honors,
I have a question. You raised the issue of the fact that that the appellant didn't file a derivative suit or derivative claim.
Yes, Your Honor.
You didn't mention that, and I'm interested in that.
Yep. Happy to, Your Honor. A derivative action, as Your Honors are well aware of, has several procedural steps. But ultimately, what a derivative action is, it is a challenge to a board of directors' authority to take some action. And what the Tennessee Nonprofit Act tells us is that members of nonprofit corporations may not challenge the board of directors' authority to act unless they have standing, first of all, which is the lesser of 50 members or 5% of the total ownership. And there are clearly not 50 members here, and the appellants do not maintain or do not have 5% of the total ownership. It also requires certain procedural pretrial matters, such as a demand, a pre-suit demand. It also requires that the action be brought in the name of the corporation against the board of directors. So that has not been done. This court had the opportunity to, has had multiple opportunities to look at derivative actions. One such case that I actually argued in front of this court was Germantown Manor Homeowners Association, Inc., the GGAT. That case was cited in our brief. And the Germantown Manor Court affirmed the law that the validity of a corporate action may not be challenged on the ground that the corporation lacks or lacked power to act. A corporation's power to act may only be challenged in a proceeding against the corporation to enjoin an act and must be brought by a member or members in such derivative suit. There is no question that a derivative suit was not filed. Here, the appellants are challenging the association's ability to levy special assessments, to set a time frame for special assessments, a due date for the special assessment. And that is, by definition, challenging the board of directors' authority, which must be brought in a derivative suit. The appellants did not do that here.
And they couldn't have, could they?
They don't have standing to do that, Your Honor. They would have had to have gotten other members to join in. Again, it's not possible because, or wouldn't have happened because every other member in the association paid. So they would not have been able to get to the requisite 5% because no one else would have agreed with their position, again, because every other member paid. These appellants are the only members of the association that did not pay their share of the special assessment, some of which was much higher. One member's share was $60,000. Every other member paid except for the appellants.
All right. Any other questions?
Mr. McNary, the 20% increase, as I understood it, was supposed to last 5 years. Did it go beyond the 5 years?
No, Your Honor, it decreased after 5 years. and they're still at a decreased state. They've gone up a little bit over the last couple of years due to inflation and things like that, but it went down drastically after the 5-year increase.
Okay.
And the purpose of that was to fund the reserves. Is that correct, Mr. McNary?
To replenish the reserve account and yes, to build it up to a point where they would not have to have large future assessments such as this.
All right. Thank you.
Yes, sir.
Mr. Cody, you have 5 minutes for rebuttal.
Thank you. Well, to answer the question, Judge Armstrong's question was the work done in 5 years. If you look at Exhibit 2 of the trial exhibits, you'll find that the accountant accounted for that money over a 5-year period, and it started when it was assessed, and it disappeared. And he specifically referred to the $385,000 coming in and going out over that 5-year period. As far as the letter, I think there's a wrong perception of the letter. The letter said that there was a $385,000 assessment made. That assessment was made, and it specifically said that that assessment was for the replacement of air and the heating system, among other things. What the contract says, in defining those, it says, all maintenance and repairs and replacements to the common elements shall be assessed to the unit owners as common expenses. Such assessment shall be made as a special common expense where required by the negligence or fault of a unit owner, and the board has actually recovered the cost therefrom, the unit owner responsible. So with the $385,000, it's definitely being misclassified or misrepresented. It is by definition in the contract and by the details a common item, because the way common items are defined basically is that common items are shared pro rata. The expenses are shared pro rata among all of the unit owners. Special assessments are paid basically by less than all of the unit owners, and that's basically the difference between those. If you look at this letter specifically says this is for replacement. The contract specifically says that replacement of common items is to be charged as common goods, and common goods are supposed to be charged over a 12-month period. That 12-month period, it says that is the 20% that's being charged. The letter also says that the 20% was passed. There can't be a charge under the contract, under the terms of the contract, unless there's an assessment. Not just the past. Basically, how the system works is there's an assessment, and there's an assessment date as to when that charge becomes good. On the other hand, there's also a payment date for that assessment as to when those payments, to start the period of when those payments are to be made. And that's exactly what happened here with the $385,000. The $385,000 was in the name of special assessment only. Everything that happened to this $385,000, it was treated totally as a common assessment, not as a special assessment. If you take the $385,000 and then you take the additional 20%, well, we're being double charged simply because the $385,000 is being assessed, and now you're trying to say that the 20% is being assessed. So my argument basically, and properly treated, that $385,000 was used over that 5-year period to take the replacement, to do the replacement of the roof, the boiler, and everything that was done over that year, over those years, and that was documented in exhibit number 2 as to what actually took place with that 20%. As far as the excess profits, definitely excess profits is basically what's left after all of the charges and the reserves are taken out. Then there's excess profits. Those excess profits, by definition of the contract, says that those excess profits ought to be redistributed back to the unit owners as overpayments. And what the court here is trying to do is trying to say, well, no, but we kept those as reserves. No, after it was determined that they were excess profits, there should have been a distribution. If they were going to take it from the unit owners, then there must be a reassessment. Can only get paid through an assessment.
Thank you. You reached your time. Thank you, gentlemen. We will get you an opinion as soon as possible. Thank you.
Thank you all. Have a great day.
All right.
This honorable court is now adjourned.